Well, welcome everybody to another OBA Bar Talk virtual chat. I'm Dave Summers, Executive Director of the Omaha Bar Association, and I'm here on Thursday, the 28th of May, talking with Scott Mertz of Legal Aid of Nebraska. Scott is a longtime legal aid attorney, if my memory serves me well, and you have done an incredible amount of work in the housing side of things at Legal Aid. And so we want to have you on today to chat about that, the impending end of the moratorium on evictions in Nebraska. So thanks for joining us, Scott.
Thank you for having me. Thank you for the introduction. You are correct. I've been with Legal Aid of Nebraska for over 10 years now, and currently I manage the Housing Justice Project within Legal Aid of Nebraska.
And now the office itself is closed to walk-in traffic to people that need to contact or have your help, correct?
It is true that we are correct to physical walk-ins. Pre-pandemic, we would have designated hours for people to walk in, but our intake lines are fully operational, both online and on the phone.
Okay. So I just mentioned it at the outset. Can you walk us through the history here since March of the moratorium on evictions and who that covers and what's this kind of new change that's going to happen here in the next few days?
Certainly. So I'll start with back in time, March 25th. That is when Governor Ricketts signed his executive order, I believe 2007, which provided temporary relief for renters facing eviction. What the governor did with that executive order is essentially create a special class of individuals who have been impacted by the pandemic in some way. Specifically, if an individual who's a renter could demonstrate that they have lost income, lost hours, had to stay home to take care of family or sick relatives, or themselves were sick. And because of that, could not pay rent on or after March 13th. That is the date the state of emergency was declared in Nebraska. If they could meet that criteria, then an eviction trial for non-payment should not occur prior to May 31. Again, what is not done in that executive order is prohibit any notices for non-payment from going forward, or even the filing of the eviction case. What the executive order did was say, for these people, trial should not occur until the other side of May 31, unless there was any extension granted, which has not occurred and does not look like that will occur. So that will end on May 31. Now, here in Omaha, in the Douglas County Courthouse, the docket basically took that executive order as a means to continue out all eviction hearings to June 1 or later, unless the filing party could motion and demonstrate that their eviction case shouldn't be subject to the terms of the executive order. That is, the eviction was not related to non-payment in any way. If you're trying to evict somebody for non-renewal of a lease agreement, or for cause related to criminal activity, or just some other violation of the lease agreement that didn't relate to non-payment of rent, then the executive order would not apply and they could continue with the hearing as normal. So eviction cases have been heard in Douglas County Court for these couple of months, but certainly not at the volume that they had previous, as most evictions are typically for non-payment of rent. Now, 2 days after that executive order was signed, then the federal government signed the CARES Act into law. And as part of the CARES Act, there is a proper eviction moratorium. I say proper because that fully puts a hold on eviction cases from going forward at all during the period of the moratorium. That lasts for 120 days, so from March 27 to July 25th. Now, that moratorium covers properties essentially covered by federal law. That is, if they're federally assisted in some way. We're talking public housing authorities, Section 8, project-based Section 8, low-income tax credit properties, subsidized by the VA or the USDA, et cetera, that's going to be covered under that moratorium. Similarly, if it's a federally backed mortgage or a multifamily federally backed mortgage, that would also be covered under that moratorium. Roughly speaking, we're talking about 30% or so of all rented properties in the country are covered by that moratorium. So even though the governor's executive order comes to an end effective May 31, again, that moratorium stays in full force and effect all the way up until July 25th.
And so you said 30% for the Section 8 housing, the federally financed mortgages and things like that. But do you have any sense on what percentage out there, how many people do you think we're dealing with in Douglas County that may be up for eviction because they couldn't pay their March, April, May rents, or not March, it would be April, May rents? Do you have a sense on how many people we're looking at here? Is there any sense from the docket that you can see?
Yes. Right now, here in the Douglas County Courthouse, the docket has upwards of 175 cases right now on file. Again, these are individuals who were sued. The filings happened obviously pre-May 31 during the course of the executive order having force and effect. Again, nothing under the executive order stopped these cases from being filed. It was just a matter of when they could occur. So for the last couple of months, cases have been filed in Douglas County, and dates have just been assigned out into June and even out into July. Now, they've been scheduling them out into the summer, but starting now, they are scheduling them out just under the regular 10 to 14 day window of time that is mandated by Nebraska's Landlord-Tenant Act. So anyone filing for an eviction case now, that hearing is going to get scheduled 10 to 14 days out. And you can see it's front-loaded, this docket that we have here in June and the first half of July, with the first week of June having well in excess of 100 cases, 100 eviction cases that are scheduled to be heard.
And I mean, are we thinking that there's going to be more, that there are maybe landlords that have been waiting to file until they had some understanding that this moratorium wasn't going to continue? Is that a low estimate, the 175, do you think?
Yeah, that appears to be the case, just from looking at the Douglas County docket these past couple of months, seeing, okay, I can see there's a few cases because they're going to be heard this week because they aren't subject to the executive order, and then seeing there were other cases that were subject to the executive order getting scheduled out into June. People were doing that. Landlords were filing these cases, that is, but the uptick in filings have gone up exponentially since the governor's pronouncement that they didn't expect to sign a extension. So people expected, if I file a case, I'm going to get my day in court in the normal course of 10 to 14 days. So yeah, many dozens in the last couple of days have been filed after just a pretty steady progress of, again, we're talking about less than 100 filings spread out over the course of 2 months in Douglas County.
And if you could help me with my civil procedure here, I'm gonna draw a blank. When it comes to the eviction process and having that hearing, run us through. Generally speaking, you're the landlord, there's non-payment, you're looking to do this, how that process goes from start to finish, before you can start to open up the property for another renter, so to speak.
If you're a landlord and you find you have a defendant late on rent, the process starts with notice. All evictions have to start with written notice. For a non-payment of rent in Nebraska, we now have a 7-day notice requirement. That is, the landlord has to, in writing, give their tenant 7 days opportunity to cure, that is, pay up or vacate the property. After the issuance of the 7-day notice, if that is not cured, the money is not paid. Once the 7 days lapse, they can then file in county court. And once they file for a complaint, they'll have a court date scheduled 10 to 14 days. This is 10 to 14 calendar days, not judicial days. So within a 2-week period of time, they'll have a court date. From there, the summons is issued that would inform the tenant of their date and time in court. And that summons has to go out within 3 judicial days of the issuance of the summons. So again, it's a pretty quick turnaround time. You have to wait the 7 days for the notice to lapse, and then there's upwards of 2 weeks, no more than 2 weeks from the court date occurring after the filing of the eviction process.
And as I guess we've read in the paper, you go, if you're a tenant and you go into the court, on your date of your hearing, and you say, I lost my job because COVID-19 and I can't pay at this time. That's not going to be a reason. When these hearings are set, that's not going to be a reason that you can then stay in your apartment. You will be evicted, right?
Correct. Absent the affirmative defenses provided by the CARES Act, that is, again, the question of what type of property you're in. Absent that being available as a defense, you're right, the circumstances by which you cannot afford to pay, your financial circumstances, your family circumstances, aren't going to be relevant. What's going to be relevant is the notice correct? Is the notice accurately reflecting the money that is owed under the rental agreement? Was that not cured after proper notice was given? And then was there proper service of the complaint? Those are essentially the steps that would be proven up at the hearing in a non-payment case.
But really, this has all been great legal analysis and an overview. But when we're talking about a landlord that wants to have a renter that's paying their rent, that they don't want vacant properties, that's their concern. There is time to clean, to vacate, to find somebody to take over that space. And on the tenant side, there are huge consequences for being evicted. And can you just run us through that a little bit? I know that there's been a legal aid event in the past that I've been to where they talked about this, and it could be huge for somebody that's evicted. Could you run us through a scenario?
Sure. First thing, a lot of people don't understand is just how quickly the eviction can happen after a hearing. I mean, that is the physical removal of a family from a property. Once there's judgment entered at your day in court, that is essentially it. The plaintiff can get that writ, and for all practical purposes, can enforce that writ as soon as is possible. The only legal requirement is that once the writ is issued by the court, then your sheriff or constable has by law 10 days with which to execute it. That's essentially the maximum amount of time it should take. So again, you have a situation where very quick turnaround, want to get that hearing, and then very quick turnaround with which the judgment is enforced. So it's very difficult for individuals to make arrangements to physically secure their property and get somewhere under the best of circumstances. Again, we're talking here during the pandemic, issues with the shelters being overcrowded and on lockdown, and alternative situations for housing being available. It's difficult for families to be commingling and cohabitating. Again, it's difficult for perhaps a young parent of children to then go live with some elderly relatives during a pandemic. That is certainly not what is advisable under these circumstances right now. Again, there's financial consequences to this, where now you've got an eviction on your record. Again, practically you've lost your housing and you've had to go secure alternative housing under very short notice. And now you have the stain of an eviction, quote unquote, on your record, on your tenant history. Anyone can find this out. This is public record now, this judgment that's been entered against you. And so that's going to cut off a lot of options for alternative housing. A lot of renters who do background checks are going to see that and going to see that you are now a high risk renter. So practical consequences with an eviction of just the immediate loss of shelter and security. Perhaps consequences is also loss of personal property. if you can't secure that, take that with you, take your things somewhere. There's the Disposition of Personal Property Act and certain protections that go with that. But even that has a deadline on it. And if you can't get your personal property out within the time frame, within when you're getting noticed to get your personal property out, you are at risk of losing, your belongings and most of your physical assets once you.
Right. So you're evicted. They change the locks on the doors. They take your personal property inside, your TV, everything that's in there. It's still inside. They move it to a storage unit, which adds to how much you owe because the tenant is on the hook for that storage and that moving, I believe. And then within a certain amount of time, if you don't come and claim it, or do you have to pay to claim it? Do you have to pay the storage and the moving costs?
Yeah, correct. You touch upon where the money comes into it. It is legal for the landlord, once they have reclaimed the property, to charge quote unquote reasonable storage fees for that personal property. The time frame you have to claim varies depending on service of written notice to claim that property. If you do personal delivery of written notice saying, come get your things and pay X number of dollars on top of it, that can be as short as 7 days. If it's just via mail, 14 days are required for written notice to claim that personal property. But yes, you point out correctly that they can put a price tag as long as it's just the only standard is reasonable storage fees that would go along with the cost that has been incurred by the landlord for personal property that has not gone with the tenant that has been removed from.
And then at the end of the 7 or 14 days, depending on notice, they can sell it. They can do whatever they want with the property.
Yeah, as long as they reasonably believe it's worth less than $2,000, they can trash it, they can keep it, and they can sell it. Property that's worth greater than that, they do have to follow more requirements for auctioning off that property. But again, not a lot of standards in place for what exactly the landlord has to prove up for showing that they think it doesn't rise to that standard that requires them to do anything more than just dispose of it as they so wish.
I wonder, I'm probably never going to get him on the Bar Talk podcast here, but Palladino and why he got into the storage unit side of things after being a landlord, I'm guessing, a closed loop of people that he's evicted and then he's storing their stuff. Maybe that was a good business move on his sense. Anyway, a little aside there. Yeah. Scott, if somebody's in the situation and they know that the hearing's coming up, they know that their landlord, has given them notice that they haven't paid, what should a tenant do? What could the private bar be doing right now to hopefully stave off this eviction tsunami that we see right now?
Couple things, primary, and I am glad about the Omaha bar stepping up to lend services and help. But the number one thing we always say, you get a notice, you think your landlord's going to pursue eviction, call Legal Aid Nebraska. If you're a renter, odds are higher that you're going to economically qualify for our services. And if you won't, we'll similarly try to place you with attorneys who could take on your case. But we advise as soon as it's on your radar that this might be coming, do reach out to an attorney to explore your rights, your options, understand what you're facing. Again, during this period, end of the governor's executive order, the federal law is still in place. What we want to make sure is that anybody who's subject to the federal moratorium is not being evicted, because there's not clear standards in place for actually enforcing that federal moratorium. Ideally, the bench is making the plaintiff affirmatively prove up in court they are not subject to that federal moratorium, but that can take that can look certain ways. It might be as simple as just asking the plaintiff to affirm under oath, I'm not subject to X, Y, or Z. I don't think that's going to be sufficient. It should be enough. If they're saying they fully own their property, they're not subject to any mortgage at all, that's easy enough to do. They can show they've got the deed, there's no liens or anything. But it's not necessarily the case that a lot of owners or property managers fully understand whether they have a federally backed multifamily mortgage. Fannie Mae, Freddie Mac might have bought that mortgage somewhere during the life of the mortgage as well. There are tools in place, publicly accessible tools in place for you to go to put in your address to see if you're subject to those moratoriums. I would note both Freddie Mac and Fannie Mae have created websites and phone hotlines during the course of the federal moratorium to help ensure people are able to cross-check and see if they're covered under those moratoriums. But those have gaps as well. It's only multifamily units that are covered in those publicly accessible databases. For just the single, no more than 4 unit covered properties that are not readily accessible pieces of information in the databases. So that in those situations in particular, you really got to be asking questions and making the plaintiffs prove up in those cases. I don't have any of these federally backed mortgages, again, multiple ones that are covered by the moratorium, and to produce sufficient evidence to that point in court. Again, that's going to be a tool that's available at the very least in these next couple of months. Absent that, there's the usual defenses, the usual suspects that are going to be still in play here for any eviction case. Waiver, I always try to emphasize that. Is the landlord accepting any money at all subsequent to noticing their tenant that they're in default and need to get out? With the rental market being what it is, there's perhaps a little more leverage to say, look, I can't pay full 2 or 3 months in arrears that I'm in right now because of my circumstances. Can you work with me and take X number of dollars, so much of those arrears right now, hold off on enforcing this? Maybe a situation where there's judgment, but the writ is being held by the court to give X number of weeks or months to get caught up. Those kind of arrangements are what we anticipate trying to negotiate if there's no legal defenses that they're going to be viable. Just see what we can work with in terms of payments, plural, going towards arrearages to hold on to the property while the writ is being held.
And on some level, the tenants that are in a horrible situation that through no fault of their own, they lost their job, what have you, and they can't pay. There needs to be kind of a looking into the future and seeing how this could really affect them, and if that means that they have to go borrow money that maybe they don't have enough money right now, but maybe it is even a better solution to borrow money right now so that you are not evicted. And as much as that is a bad situation because you have to pay interest on that, and that can add up, it also needs to just be thought about: is there a way to stop this eviction, because this could lead to a really bad result. And take a situation where, okay, you're evicted from your $1,000 a month or $900 a month apartment. You can't find another apartment. You lose your personal possessions because you can't pay for that storage unit fee. And so then you have to go buy new possessions. You have nowhere to live. Your difficulty in finding work becomes even worse because of your homelessness. I mean, it's just that's compounding. That really needs to be seen and understood by the people that are talking about solutions here. That we need some compassion for those people. That's a huge burden that people that are being evicted could end up having.
Correct. I fully agree. And the hope would be, by now or in the immediate future, that there's greater rental assistance coming to those via federal money that's getting filtered through the local governments for those who have been protected at least from going to court for a couple of months, but still owing money that is accruing. And again, even under that federal moratorium, if you're subject to that and you're safe through July, again, the money's still going to accrue. I have not mentioned during this call, late fees, charges, that's prohibited under the federal moratorium, not under just the statewide executive order. So there may have been accrued fees for individuals who have been protected under the executive order for these couple of months. That just increases the bill. That's
what are the, like, are those a percentage of your rent, or what do you see out there when you're looking at these leases and what they assess in those fees?
Completely varies. Again, some try to have something as just a daily rate, and there's a question as to whether that's actually enforceable, because that can add up to an amount of interest greatly in excess of what just basic usury laws should allow for. Some are more of a flat, okay, by the fifth day we're looking at $25, $75, etc. Sometimes when it goes to court, they want to see the filing fees and the court cost paid for by the defendant if they're going to dismiss and keep them in the property. Hundreds of dollars right there thrown on top of the balance.
Wow. I'm doing all this out of order here, but Scott, how'd you get into this position, into doing this? You're passionate about it clearly, and you understand it. What's your history on that?
Well, as long as I've been at Legal Aid in Nebraska, and that corresponds to as long as I've been a practicing attorney, I've always done some manner of housing work. I've done other things off and on as well, but just a consistent through line has been doing eviction defense work. It's one of our priorities here. Our focus is helping low-income individuals protect the family unit and victims of domestic violence in particular, with keeping their children and keeping their resources, but also keeping their income via our creditor-debtor issues, keeping their public benefits and access to public benefits. And the fourth one, shelter, housing, that people are able to live in safe, affordable, habitable housing in the state of Nebraska. These are just the basic necessities of life. And if individuals cannot afford an attorney, they should still be able to have those basic necessities of life. And with housing in particular, it's tough because, as we've highlighted, the turnaround time in these cases is so quick. It is very difficult for individuals who don't often do that kind of law to roll up their sleeves and just hop in on short notice, because the train leaves that station and it gets to a hearing, a trial, more or less, rather quickly. So it's important that there are attorneys who are practiced in doing this kind of work and are able to provide assistance on just really short notice, just really a few days' time. One is coming to an attorney before they have court. And so we want to make sure here at Legal Aid in Nebraska, that is an option for individuals faced with eviction, that they can get quality advice and counsel, and if necessary, legal representation in eviction court, and that they're not going in unrepresented.
It is such a huge ask and lift to do that. You've talked about it a little bit here. There are income guidelines for people that are looking to legal aid for help. If you qualify under the guidelines and there isn't a conflict, say, well, it wouldn't be in the landlord-tenant situation, but if you qualify and there's capacity and there's no conflict, then legal aid can take on your case at no charge to the person, which is huge, because I guess, well, constitutional law, you have a right to an attorney in a serious criminal case to represent you, at no charge to yourself. Well, actually, no charge is not part of it. There may be a charge, but in a civil setting, generally speaking, you don't have the right to an attorney free of charge. And so legal aid has sort of stepped into that role. There are a few other organizations around town, but legal aid's the big one. And the work that you do is so important. I would say anybody who wants to obviously support what you guys are doing, there are donation links on your website for tenants who need your guide of what to do, maybe before they call in right now, if they're wondering what we're talking about and want more details, you have a great page, landlord-tenant page on the website for those people to see that, and then calling in and trying to get legal aid to take on their case. It's just incredible the work you guys do, and I'm a big fan of. Obviously, we've done fundraisers together in the past. My wife's on the board. You guys are past service award winners, recipients from the OBA. So it's been a long-time admiration, and I just really want, hopefully, people understand what's coming here and what they can do to protect themselves and attorneys can do to protect clients from potentially being evicted, because nobody wants to be evicted. Nobody wants people to be evicted for the most part. They want things to continue as normal, but this is not normal, right? So
I would hope that's true. I would hope the majority of the bar and the bench is going to be more amenable to circumstances where things can just be worked out, delayed, or just more time given on certain cases in light of how serious the pandemic still is and how serious the economic effects of the pandemic still are in the state. Again, I would just point out, anybody listening or watching this who has an interest in volunteering their services through OBA or doing more to help with the expected greater number of eviction cases coming to Douglas County Court, but is just concerned about their level of expertise in the area. I personally, and this organization generally, is always just open to any advice and counsel and help with answering any questions you have on landlord-tenant law. I expect to be there at Douglas County Court, certainly more than I have in the previous 2+ months in the coming months. So I'll be there physically, but also available via phone and email at Legal Aid Nebraska's Omaha office.
And I know that, and we haven't mentioned it here, we mentioned it before the call, but the Omaha Bar Association Lawyer Referral Service does have attorneys that practice in this area. Certainly, if you can qualify for legal aid and get in legal aid, that's better. If you can't afford your rent, affording a private attorney to take on your case is generally not an option. But the lawyer referral service, if nothing else, if you cannot get into legal aid, talking to an attorney that can walk you through what your rights and remedies are, 30 minutes, $40 is certainly worth, I would say worth the money if you can understand exactly how you can potentially get out of this situation without being evicted. So I appreciate we're working together on this, Scott, and it's part of a larger need for all the legal assistance needed right now, more than ever in the state and in the country. So I do appreciate it. Is there anything that I didn't ask? Was there a softball that I was supposed to get in there that I didn't get, Scott, that you want added?
I think we covered the basics. Things are bad, and we don't know how bad they're going to be, and that's why there's a great need to put more resources into eviction defense work. I don't think, again, I touched upon, again, the federal moratorium, again, still in effect through July. No late fees or charges should go along with anyone subject to that moratorium. I did not mention that if you are covered by the moratorium, you're entitled to a 30-day notice to quit, notwithstanding what the state of Nebraska requires at the end of the moratorium. So we really shouldn't be seeing people in court who are protected by the moratorium until way out into September of 2020. Ideally, that's going to help a little bit with keeping the numbers a little bit at bay in these coming months, but people have to actually follow the moratorium in order for that to be the case. So we'll just be seeing how that goes in the coming months.
And I guess there are still days until June 1st, and so there's still the opportunity to change the end date for the moratorium on the state of Nebraska, but that is all in Governor Ricketts' corner, I believe, correct?
Yeah, I think the expectation is that all but said that's not going to happen. But there was no executive order until there was an executive order signed the first time, like on March 25th. So
I know some people will just want to get on their social media and and do some lobbying, some couch lobbying of the governor on this. So I guess there's always that avenue, but we're realists here, and we're going to just deal with what we see as happening in our immediate future. So, well, thank you so much for taking the time today, Scott. We will pick this up later. I'm sure I'll have other legal aid attorneys on in the coming months as we keep on dealing with this. But thank you for being on the front lines there, and we'll continue to send support and people your direction to hopefully stem the tide here a little bit. So thank you so much.
Thank you, Dave. Appreciate it.
Have a good day.
You too.
Bye-bye.